Welcome on this lovely rainy Sunday afternoon. We're glad that you were able to join us to hear Megan Salisbury educate us on estate planning. So we're a small enough group. Megan, I'm guessing it's okay with you if people ask questions as we go along?
Absolutely.
All right, I'm going to let you introduce yourself. Megan
Perfect.
Salisbury.
So Megan Salisbury, I'm an attorney here in Eugene. Have practiced since, let's see, 2011. I was first licensed in California, and then I was licensed the next year in Oregon. So I do both California and Oregon estate planning and probate and trust administrations. Due to the desire to have a very good work-life balance, because I've got 4 kids. I started my own firm after working at some of the bigger firms in town, and realizing I needed more actual work-life balance than they were able to offer. And so I focused on estate planning, both while I was working before going to law school, and then during law school, I obtained a certificate. In law school, you don't focus like on one area of the law or the other. You kind of learn everything. But you were able to get certificates in certain areas. So my certificates are in tax and estate planning. I do this a lot. It makes a vast majority between this and then probate administration of estate stuff, makes the vast majority of my practice. In addition, I represent people in different capacities when it comes to protected proceedings. Now, some of the documents we'll talk about today avoid the need for protected proceedings in the vast majority of circumstances. So they're great to have, but sometimes we get somebody who comes in and either we can't find a power of attorney that was ever executed or they never did one. We have to get the court involved to establish somebody to make decisions for them. And that's what a protected case is called. It's a conservatorship or a guardianship. So if we can avoid those, I'd much rather, get the vaccine versus getting sick. So that's what this is about. But yeah, so that's kind of a little bit of history. I guess I went to U of O for both undergrad and law school. So go Ducks. Yeah, that's kind of a big, a summary of who I am. Definitely happy to answer questions later if they come up about any of that. Are you guys ready to kind of jump into the topic at hand? All right, that sounds good. I'm going to attempt in all of my love for technology to screen share. So let me, oh, there it goes. You just make sure it goes on to presenter mode, present to meeting. Okay. And can you guys see that, or do I need to update it?
Can't see it.
Let's see, screen share. There we go. Okay, now everybody see it now?
Yes.
Yes.
Okay. My love for technology is minimal. That's okay. Okay, so I figured we would talk about a couple things in estate planning. The first would be about things like advanced healthcare directives. Second, we would talk about different types of powers of attorney. A third is disposition of remains. And then the last one, we would just kind of touch quickly on wills, because most people have a lot of questions about wills and trusts. But I know it's not the focus of kind of what the conversation is about. So to jump in, and you may not be able to see these very well, but I at least wanted to put them out there so they kind of look familiar. Every few years, there's a committee in Oregon that creates the advanced healthcare directives that we are required to use. And sometimes we like the changes the committees make, sometimes we don't like the changes that the committees make. But the overarching goal of an advanced healthcare directive, regardless of which version you ever fill out, has to do with who can make medical decisions for you in 3 very specific scenarios. Here it goes. And so what you're looking at is, okay, who do I trust to make these decisions.
Megan, excuse me, can you make
Yeah.
that any larger?
I was just,
I don't know if I can, if it will let me zoom.
This is Mariana. Now on the iPad, I can make it larger just by push.
By zooming it.
And I think on PCs, if you hit the Control Pound key, it'll probably make it bigger. I'm not
Okay,
sure.
let's get that track.
Control Pound.
And I'm like, Control Pound. All right, we're gonna figure this out, guys.
That's not Pound, I'm sorry, Control plus sign.
There we go.
Sorry.
No.
It's making it mildly bigger. Let's see.
And you can hit, well, I'm thinking of people individually on their PCs.
No.
Yeah.
Yeah.
No?
No.
Well, and I'm
Okay.
able to, so these are, it's just an example of what,
Yeah, that made it smaller, I think.
well, I think if you don't hit, let's see. Let's see, I am at I'm at 500%. So it's not letting me get any bigger, whoopsie. But so the document, I'm happy to send you guys an actual copy of the document.
Right.
So I'll email that over to you so you can have it for people to look at.
Sure.
But it's the same, it should be the same one that you get from like the doctor's offices. And what happens is if you don't have one of these filled out, doctors ask about it at really, really bad times. Normally it's like, hey, you need to have something done and have you filled this out? So it's nicer, it's less stress to fill it out when you're not under, other situations going on. But I'll definitely send it to you guys so you have a chance to look at it. It's 8 pages in total. But the important parts of it is the first page just talks about definitions, right? Like how do we define tube feeding? How do we define life support, dialysis, those kind of things? How do we define certain situations, permanently unconscious, close to death, advanced progressive illness? And one of the big changes they made in this form, the last go around with the committee, is they added in some sections, and it takes up about 3 pages of it, where you get to put in decision, like things that are important to you, right? Who are people that you should, that the person who's making these decisions for you, who should they contact before making these decisions? If that, maybe some people have that, other people's don't. It kind of depends on who you appoint. Other things that they ask you about it, like your religious beliefs. Is there anything in particular you want someone to know about those, feelings? Like, do you want someone, usually like for Catholic, right? You'll have like last rites ceremonies. For some other cultures, it's, after someone passes away, open the window for the next 30 minutes. It's different cultures, different religions have a variety of thoughts about that. And so this kind of gives some idea of these are things that are important to me. Other things that allows you to put in there are very existential ideas of like, what does life mean to you? It's what it really is asking about is the person that's making this decision for you. What do they need to know about what's important to you in your daily life? And so I have some clients that fill that out completely. And it's great because whoever they've appointed gets a better understanding of who they are. On the flip side, I have some clients that filled nothing out and they're like, we'll just have the conversation later. And that's fine. So that's kind of one section of the document. The other sections are, you put your information in, of course, so we know who's making this decision. And then you choose 3 representatives in consecutive order. They cannot serve together on an advanced healthcare directive. They have to be in consecutive order. And it can be anybody. It can be your friend. It can be a child. It can be anything. That part doesn't matter as much. The part that matters the most is that that's the right person for you. And then the next section, which is—
I have a question.
Oh yes, go for it.
I'm unmarried and I don't have children, but I have siblings. I have 2. I thought I could put them both as equal parties for my advanced directives.
So on the advanced directive, you put them in consecutive order, right? So it's going to be, who's your first person to make those decisions, second.
So I
and
can
third.
put them equally.
Not on an advanced directive. On a power of attorney, you can. You can put them as co on a power of attorney. Yep.
Okay.
Yeah. But yeah, and that's a great example, right? Okay, spouse first, and then maybe I don't want them to serve individually. I feel like they would serve better together, and that's totally fine on a power of attorney. The main reason why doctors don't want co's is because they need to have a definitive answer quickly as to who gets to make decisions. And that's why in a power of attorney, an advanced directive, unlike a power of attorney, the advanced directives, you put in their name, their address, their email, their phone number, like all of their contact information, because it's really the hospitals or the medical providers that are looking more closely at this document. So when it talks about, again, an advanced healthcare directive only applies to 3 scenarios. And this is, of course, if you cannot say these scenarios for yourself. And so the first is you are close to death, which means think of it more of like being on hospice, right? Like it's within a certain period of time. No matter what they do, they're not anticipating you're going to be making any kind of recovery. And then it asks the questions of, do I want tube feeding, life support, dialysis? Do maybe I only want a few of those things? Do I want nothing at all to be able to die naturally, but without pain? Or do I want to have my medical representative talk to the doctor and kind of figure out the best course of action? And so you get to choose whatever feels correct for you in each of those scenarios. So close to death, permanently unconscious, that one kind of makes sense. You aren't able to express what you'd like, and it's unlikely you're ever going to regain consciousness. And then the last one is an advanced progressive illness. This one's more of the iffy one. It means that you have an end stage of a disease. You are unable to recognize family. You're unable to communicate your desires. You're not able to provide for your own feeding and toileting by yourself. You're not conscious of those around you. Like if someone walked into the room, you couldn't say who that was. Not only because you wouldn't recognize them, but you also couldn't communicate that. But it doesn't mean, unlike hospice, right, which is a very short period of time usually, advanced progressive illness can go on for a while. And so sometimes this comes in and this document acts for a long time with someone with an advanced progressive illness. And again, in that situation, you would be giving the instructions to the person that you've picked to say, okay, I either want these things, I want tube feeding, life support, dialysis. Maybe I just want, tube feeding, but no life support, no dialysis, which is the life support's like the breathing machines. And or I want nothing, just let me go naturally. Or it's talk to my doctor, see what makes sense. So that document, it's very rigid. It's not something we can change a lot of stuff on because it's drafted by the committee every few years. And so when you execute it, right, it either has to be notarized. So someone watches you sign, notary stamps it, good to go. Or it's witnessed by 2 people not named in the document. So if you name, for example, your husband and, a sister or children, those people cannot, they can be there while you're signing, but they can't sign on it as a witness saying that they saw you do it. And that's just it. They do it to make sure that no one's giving undue influence with the decisions that are being made. So if you have friends that you're not naming, that works. If not, a notary works great too. Now, when you're done with that document, there's the very last page, page 8. And what page 8 does is it says, all of the people you name will sign consenting to act the way you have asked them to act. And let's say for whatever reason, you can't get it to your, to one of the people you name, they're off in Hawaii having a good time, and something happens. Your document is still completely valid, even though that person hasn't signed off on it, saying that they consent to act. So that part, it's important to have it done at some point. But the fact that you've signed it and had it notarized, or you've signed it and had it witnessed, is sufficient to make it a completely legal document. So that part is good. What we normally end up doing with that is once you've completely filled it out, everything's been notarized, we've gotten all the witness signatures, and we've gotten everybody's consents, is not only do you get the original, but it goes out to the people that you've named. Because then if something happens, they know that they can act, right? They can know, oh, husband's still alive, it's his turn to act. Or, oh my gosh, person who's named number one isn't, doesn't have capacity or has passed away. Now we need to step up. What's very frustrating for people on the other side of this, right, who get named in documents, is that, like, if I have a client and she is in the hospital, but has not been deemed incapacitated by her doctors, I cannot give that document out without her consent. And so that becomes a very sticky situation if all of a sudden they're saying, no, we need this, like, let's say, spouse comes to me and says, we need her document. And I'd be like, I can't do anything until she tells me I can give it to you. And that can become very difficult. So giving copies out to people saves that problem, makes it easier for everybody to do what you guys need to have happen. During your lifetime, you can revoke it at any time. So even though you've given it out, let's say you gave it out to your kid and they've got a copy of it, you absolutely can revoke it, change it at any time, change the people that you want to list, change the options you've made. Totally something you can redo as many times as you want. So that's a good thing. I have on the very last part of that slide, two things. One, they must act in accordance with your wishes, right? So in this document, you're making your wishes known. You're saying, if I'm in, permanently unconscious, this is what I want to have happen. So if I fall in that definition, I've told you what I want to have happen. They have to follow those wishes. The second part about it is that if you don't execute one of these, an advanced healthcare directive, and you're unable to make medical decisions for you, then first your spouse will be able to make decisions for you. And for a lot of people, that's great, no problem. The problem is if you don't have a spouse or that spouse has predeceased you, then the medical facilities have to find somebody who can make medical decisions for you. Whether that be one of your kids, maybe you don't have any children, so now they're going to try to find siblings. Often it ends up resting with a niece or nephew who may not know what you'd want in those situations, who may not be the best fit for that, making those decisions. And often at that point, then they will have to go get a guardianship to make those decisions for you, which is it's a court filing. It's the court declaring that you're incompetent, meaning that you lack the ability to, essentially, it means you are lacking the ability to understand cause and effect. And then once they do that, you remain under guardianship for usually the rest of your life. It's annual reporting to court. It's a bit of a clunky process, but that's kind of what happens if you don't have something like this in place.
Okay. This is Mariana, and I have done my advanced healthcare directive. I just wanted to add that I have an addendum to my directive, which is, anyone can do this. You can just write whatever else you want people to know. And I have a 2-page addendum, an attachment that just talks about how I view what I would want. And so it's part of the document. And I have a sort of a copy of that attachment without my name associated to it as a PDF, which I could send to whoever's collecting things for the common use. I'm happy to share what my addendum says, just as an example for people. So just wanted to.
Great, thank you.
Yeah, and it's interesting because they started, I think one of the reasons they made a lot of changes to the document on this last go around was because people did want addendums. They wanted extra spots to put information about how do I feel about certain things, or what's important to me, so that the person making decisions would have that information. And because now we see a lot less addendums because people are saying, oh, I can fit this all in. But if you can't, or you want to add something different, absolutely, you can add that kind of stuff in on an addendum.
Okay.
Yep.
I'm trying to think what those things might be. Just random examples, Mariana?
Well, no, basically I'm just stating that, in fact, stating and restating my position, which is I want palliative care. I do not want my life prolonged. I do not want life-sustaining treatment to be provided under certain conditions, like if I'm in a coma, etc. So I'm just stating and restating. And what do I say? I say this is meant to be a help to my agent and my healthcare providers. I have spoken in depth to my agent of my wishes, but I can't identify all possible situations that may arise. And I leave it to my agent to use best judgment, carrying out the spirit of my intent. And so basically it's giving someone the feeling of what is the spirit of my intent for myself. Not so much, we've already detailed it in the document, but I just want to further explain my view of what I wish for myself. And you'll be able to see it in the example, Phyllis,
Okay,
because
thank you.
it's very clear. And I actually, in the example, I state the same thing 2 different ways, page 1 and page 2, because when I first did an advanced healthcare directive in California, I used a different form, which had slightly different language. And so I thought, okay, I'll state the same thing 2 different ways, just to really make sure I'm clear about what I want. This is it. So you'll see that, and you can feel free to use or not use any of it that is in the document.
Thank you.
Okay.
What they added in on this version of the Advanced Healthcare Directive, the Oregon Advanced Healthcare Directive, were things like let's see, what matters most to me and for me. And so it's like, this is what you, the person I'm appointing, should know about what is important to me about my life. This is what I value the most about my life. This is what is important for me about my life. If you choose no life-sustaining procedures, there's some sections where you can initial what that means to you. There's a section about spiritual beliefs, where it talks about, do you have a spiritual or religious belief that you want your healthcare representative and those taking care of you to know? They can be rituals, sacraments, denying blood product transfusions. That's a common one. Or more. It's a spot to talk about life and values. There's a spot that talks about nursing home care. Like, yes, no, maybe so. I absolutely don't want this place. That kind of stuff.
Now that sounds like a different form than I've used, so I'd be interested in seeing your new form. Thank you.
Yeah, so it came out in 2021, and it was a dramatic shift from the 19 version. The 19 version was much shorter. It didn't ask you any of this like major, life questions.
Okay.
It was more of like, who do you want? And these are the scenarios. And so it's definitely a very large shift from what they had done before.
This applies for the state of Oregon, this revised by committee document?
It's an Oregon one, but let's say you were traveling somewhere else. They are going to honor that document. So even if you're in Colorado or California or New York, they're going to still honor that.
So you should carry a copy of that with you when you travel.
I know a lot of people that do. Yes, they will carry it with them.
That just seems beyond.
It depends on how risk averse you are.
I mean, I'm going to my nephew's wedding in California.
Well, yeah, I would add that I have a copy of whatever document I have as a PDF on my computer, so I can copy it down to a little jump drive and just carry that with me rather than a document. But
that makes more sense.
Whether anyone would look at it is another question, but
I have a question about the representatives. If I have 3 representatives in my document and they can't find number 1, are they going to just jump down the list until they get someone?
You got it. Yes.
So even, for example, if my husband is my primary decision maker on my behalf and he's somewhere else, that means the next one in line is going to be called to make that decision.
They will go down as far as they need to go, depending upon how emergent the decision is, right? If they've got time to, like, let's say they call in your husband's playing golf or something and they can't reach him. If it's not a decision that they need immediately, they'll probably give it a little bit. Let's give it a couple hours, half a day, and they'll call back again. If they call 2 to 3 times and they cannot get a hold of him, then they will jump to the next person. But let's say he is then found, right? And rushes to the hospital, he's going to get priority as number 1. So it will kind of revert back if number 1 shows up.
Thank you.
And that happens automatically. If number 1 shows up after number 2 has made some decision, number 1 then takes priority.
Yeah. They don't really get the ability to question number 2's decision. And say, oh my gosh, how horrible this was of you that you didn't, try for the 5th time to get a hold of me. But at that point, because they are listed first in the document, they take priority.
All right.
Okay. Any other questions on the excitement of advanced healthcare directives?
Is there a standard form for that available from the state of Oregon or someone?
You can, it's, let's see, I'm trying to think of where we get it from. Normally someone on our listserv gets like first copies and then they send it out. Your doctor's offices have them.
The hospital has them.
Yep, all of the medicals. Yep, they've all got them. But you don't have to have, and some of them, it's like in a printed booklet, right? Where you like, it's folded all sorts of funny ways. You don't have to have one of those, just regularly printed on paper is fine. So you don't have to have a specific, like it doesn't have to have come from the doctor's office. We often do those here because we're already making you talk about uncomfortable things. So let's just, kind of get it over with. So, good.
So Megan, you're going to share that document with?
Yeah, I will email it over.
As a PDF or something, yeah.
Right, and I can send that out afterwards so everyone can access it.
Yes.
Great.
Yep, not a problem.
Good.
Thank you.
Oh, of course. Okay, if everybody's ready, I will go on to the next one.
All right.
All right, here we go. Okay, so switching gears a little bit, our powers of attorney. And a power of attorney gives the powers that you want to give to somebody else to make medical and financial decisions when you are unable to do those for yourself. Now, there's different types of powers of attorney. A lot of the times, people want what are called durable powers of attorney. And what a durable power of attorney means is that I execute it today and it lasts through any incapacity, right? So it's just as effective on day 1 as it is on day 365 when I've lost capacity. And it will continue until I pass away. That's a durable power of attorney. Other ones are called springing powers of attorney. And a springing power of attorney means I execute it today, but it's not effective until day 365 when I've actually lost capacity. And then it will continue through incapacity. It will go away if I ever lose capacity, if I ever regain capacity. But it also terminates when someone passes away.
Wait.
Yes.
I didn't catch what you said.
No, that's okay.
The
So
springing power of attorney becomes effective when?
So let's say you issue it today, right? You say, okay, I want to give my husband power of attorney, and you execute it today, but it's springing. So you say he gets to start acting on my behalf when I've lost capacity, or when I go to the Bahamas trip, or when some event has happened. Up until that event happening, that power of attorney is not in place.
Okay, so that implies something that I'm confused about. If I have a durable power of attorney in place so that my estate planning is in place, but I'm capable, does that, if having this durable power of attorney put me in some kind of liability with respect to being able to make my own decisions? It's unclear. There's something about what you shared that I guess raised that question for me.
And that's a great question. It's a fantastic question. We run into that problem in certain situations, right? Because let's say you have your power of attorney and you give it to the bank. What the bank is going to say is, wait, you have a power of attorney. And now we're going to say that your power of attorney is the one that needs to act on your account. So things like a durable power of attorney, you don't necessarily, you kind of want to keep those a little bit closer. Instead of like handing those out to your banks. Unlike at like the doctor's office, right? Like share your advanced healthcare directive with everybody because you want them to find it if it's ever needed. But with a durable power of attorney, that person can act for you starting on the day that you execute it. Now, lots of people choose durable powers of attorney because we don't want to have to decide when you've lost capacity in a very real sense. It's hard to pinpoint that in many cases because sometimes capacity looks different on different people. You know, if like capacity, when I look at determine someone's capacity when they have vascular dementia versus Alzheimer's, that's a very different looking at what can they do, what can they not do, what do they understand. And always in my mind, because I do guardianships and conservatorships, is the family upset because you're making decisions they don't agree with and saying, oh, grandma's lost capacity because we don't like that she's, going and spending every day shopping. They don't like that decision. And then I have to think, what's the motive behind not liking the decision? Versus she doesn't have the capacity to understand that if I go and spend my last $10 here, I can't pay for like rent this week or whatever. So there has to be a cause and effect because you can always make bad decisions. No one can ever stop you from making poor decisions. But making a decision when you don't understand the consequences, that's when we talk about losing capacity. And that's that's the legal definition. That's what we look at legally. So anytime somebody comes to me and says, hey, I think I need to get a conservatorship for some family member. When I go out and meet with the family member, I'm really looking for, do you understand, can you explain to me not only historical fact, right? Your birthday, who your family is, tell me about what assets you have. What month is it? Who's the president? Why does everyone wear masks? I mean, like we talk about that kind of more current, like some historical, some current, but then I ask them a lot of cause and effect questions like, oh, did you have lunch today? And they'll tell me whatever. And then I'll be like, what happens if you don't have lunch? What happens if you don't do these things? And they need to be able to explain to me, well, then I'll be hungry. And if they can't correlate those two like together in some way that makes sense, then we've got a capacity problem. Now with a durable power of attorney, I don't ever really have to get to that. I don't really ever have to say, okay, I have to get a capacity determination. Now, sometimes springing powers of attorney make 100% sense, right? I'm going to take my friend's kid with me out of state. She gives me a springing power of attorney that says, if my child is with you and not in the state of Oregon, you have the ability to make medical decisions for her. That makes sense because it's very clear, right? We're out of state. She's with me. I can make a medical decision. But in most situations, we're not at that. That's not as black and white. It's very, very gray. So a lot of people don't like springing because of that reason. A durable power of attorney, and that's why the decision of who you choose is really important, right? Because a durable power of attorney is effective the date that you sign it. So as long as you're picking, and that's always the conversation I end up having, if you trust the people that you're picking, then it shouldn't be scary. If you don't trust the people or you're iffy on the people that you're picking, then let's pick new people.
Yeah, right.
So it's like, most of the time where we do okay with, spouse, that's usually fine sometimes. It's when it's not spouse that we usually have a lot more of a conversation of who's the right, fit and who's maybe not the right fit. And we'll talk a lot more about that because there's different options to consider as to who would be the right fit and who's not the right fit. And maybe they're the right fit for medical. They'd be great at making a medical decision for you, but you don't want them ever touching your finances. And this document doesn't have to be one document. It can be two documents. You can have a power of attorney for medical and a power of attorney for financial. I get a lot of people that are starting to do that because maybe they trust kid number 3, who's the nurse, to make good medical decisions, to understand what's going on and say, okay, yeah, I understand what the doctor's talking about. And maybe they don't trust that same kid to make financial decisions for whatever reason. Or so there's a lot of times if we can have more players helping, that's usually helpful because then not everything's resting on one person, and it offers checks and balances. Okay. There was a lot. There was a lot of different stuff in there. Do you guys want me to clarify anything or go back over any of that?
Well, let's move on.
Okay. We're going to go to the next one. There we go. Okay, so one thing that's different in a power of attorney than an advanced healthcare directive is you get to decide what powers people have. And some of those powers we need, right? So one of the big ones, which is not a common one in an advanced healthcare directive or a power of attorney, is the ability to open a bank account. And if it's not in there, a bank won't do it. So the language in a power of attorney is very, very important because you're only giving the powers that are in that document. So if it doesn't say, let's say it says that you can't collect rents, then if you have a tenant, that renter can't pay that power of attorney, or attorney, in fact, as they call them. Let's say it doesn't authorize the buying and selling of real estate, then they can't do that. And what happens is, I mean, some people really want to tailor what someone can do on their behalf. But if, let's say, something comes up and we're like, no, you've got to go on Medicaid, we got to sell the house, you're moving into long-term care, your power of attorneys doesn't say you can sell the house. We have to go get a conservatorship for the purpose of selling a house. So that language is really important. And so in the power of attorney that I've got, it's a pretty extensive list that says, they can do a variety of things. And then over time, I've developed in other checks and balances in that because of experiences that we've had where Adult Protective Services has asked me to come in and represent a client. And I'm looking at her power of attorney, and not only am I frustrated, but I get the DA telling me, yes, there was clear financial elder abuse, but we can't do anything because her power of attorney doesn't say that the bad actor, right, the bad acting person who took all this lady's money couldn't use the money for herself. I was very frustrated by that response one time from our local DA, one of our local DAs, feeling like, do you understand what a fiduciary means? Like this, it was mind-boggling to me that this was the response. But I took that response and I said, okay, we're going to make it really clear. So like in my power of attorney, I have a whole section about accountings. They have to provide accountings to you if they're going to be doing anything with your money. Not only to you, but to any guardian you may have, any conservator you may have. If you have an attorney, they have to provide it to your attorney. I want them to find somebody with capacity that's going to look at it and say, okay, this is appropriate spending, or no, it's not. Because that's how we can catch things very early on instead of it being 5 years down the road and there's no way for us to ever recoup that money that's been taken. So things like that are in there. Things like I have a statement that specifically says that they are acting in a fiduciary, that the person you appoint is acting in a fiduciary capacity, which means they can only do things for your benefit and how you would want them to be done. And that's one of the important things. It's, we have, like it said earlier in the advanced healthcare directive, it talked about, you don't want blood transfusions. Well, let's say you're not in one of those end of life or permanently unconscious and advanced stage situations. Now your medical power of attorney is in play. And it's important to have those conversations with them as well to say, I don't believe in things like blood transfusions, or I don't want to go through bout 4 of chemo, or just tell them those things that you don't want to happen, because then if you lose capacity, they can't come in and say, I know grandma said she doesn't want that, but I do. So let's do it. They can't do that. It violates your rights. And so it's important conversations to have with people that are going to be acting in your place. Other things with the power of attorney, you can get rid of them at any time. You can always revoke it. It has to be in writing. But if someone's not doing what you want, then you don't have to keep them. The nice thing with the power of attorney, with at least a durable, is that we're not determining capacity, because that hinders an ability for you to say, I don't want that person. And instead you have to rely upon adult protective services to come in and say, we don't want that person. And that's not as much of a friendly position to be in. So that's kind of what, some of the stuff about powers of attorney. But I think in general, they can step into your shoes, and that's what they do. They step fully into your shoes. They can act as you would act. And they can make both medical and financial decisions when you're unable to do so. Now, if you ever regain capacity, right? Like, let's say it's a temporary thing, like you're going in for a procedure, you're unconscious because you're in the procedure. Doctor comes out and says, oh my gosh, we found this other thing, we want to deal with it. Your medical power of attorney could then step in at that point, say, yep, that sounds good, let's take care of it. They would say, great. And then when you've now recovered and you're no longer under anesthesia, you have fully regained capacity and you now continue on your way of being able to make your own decisions. So it's good in a temporary basis. It's good in a long-term basis. But yeah, so that is the funness of powers of attorney. You guys have any questions about those ones? And I'm happy to send, I can give you the template that we've created. Obviously I can't have names and stuff on it, but we can give you the template of kind of like, what do the power of attorneys look like? Most people nowadays, well, I would say there's a bit of a shift. For about the past 5 years, everybody's wanted joint durable powers of attorney. I mean, one document, medical and financial, naming the same people. Sometimes they name individuals, sometimes they name co-s, they'll name two people together, kind of like what Judy had talked about before. Sometimes they name professional fiduciaries, because that might be the best solution. So it's whatever anybody's comfortable with to make those decisions. So that's been the trend for a long time, has been durable powers of one durable power of attorney. I'm noticing a little bit of a shift in people wanting separate, one medical, one financial. So I'll send you the joint one, because what we do when someone wants a shift is we just take the regular durable and we take out the pieces as people tell me to, and say, okay, give this person all these decisions and this person all these decisions. But it's based on that individual person's choices.
I have a question. What's
Yes.
the difference between advanced healthcare directive and a power of attorney for medical?
Good question. That's a great question. So an advanced healthcare representative only acts in those 3 scenarios. So if you are not in one of those 3 scenarios, advanced progressive illness, and again, where you've lost capacity, because many people have advanced progressive illnesses and haven't lost capacity, so the document wouldn't come into play. You are permanently unconscious and unlikely to regain consciousness. So being under anesthesia is not a permanent unconscious. And then the other one is if you have, or you are close to death. They anticipate you passing within about 6 months or less. So if you're not in one of those 3 categories, then your power of attorney comes into play. So that's like the example of, let's say you've lost capacity, but you just need to have a doctor's appointment, or they need to make a decision like, should we go on this medication or not go on this medication? Your medical power of attorney will act in those circumstances.
Like if I have dementia.
Yes. Yeah. Let's say you have dementia, you have Alzheimer's, you have something like that where you've lost capacity or you're quickly losing capacity. Then that's where the power of attorney would come in and say, oh, we need to go see the neurologist, or we need to go see an oncologist for cancer, or whatever kind of doctors you were going to. That power of attorney would act in that way. And it's they're making the appointments, they're attending appointments, or let's say they're out of state, right? Because often if it's a family member, they may not live here. And so a lot of the times what happens is you can name someone who lives wherever, but they're not able to actually attend those appointments with you. They can, if you're at a care facility, sometimes the care facility will be able to facilitate that. Option number 2 is that there are companies in town that do what are called care contracts. And what care contracts are is they basically coordinate care all the way from you need in-home caregivers to you need someone to accompany you to doctor's appointments. They basically become the legs and the eyes and the ears for the power of attorney who lives out of state. And so they can, and often they'll bring you to the appointment and then they'll get your power of attorney on the phone, and that power of attorney will participate by the phone, but there's still somebody there that they can talk to as to, what's going on.
Okay.
So so that's how they work a little bit different. But if you're in a situation where you've lost capacity, and it's about tube feeding and life support, that's when we're talking about the advanced healthcare directive.
Okay.
Yeah. So usually think of that one as like end of life scenarios. Like that's really where that document comes into play.
Okay, thank you.
Mhm. All right. Any other questions? We can always have questions later. I like to think of questions like hours after, so it works out. I have many clients, they'll come in and be like, here's your presentation. And they're like, okay, we'll think. I'm like, that's cool. We can talk about it as many times as you want. Okay, so, and we'll go over this one. And I don't know how many of you are familiar with this form, but I'll give you a copy of this one as well. I just have to take some people's names off the one I've got sitting in front of me. And then we'll jump into like how do you make a good decision as to who should be making these decisions for you? Things to consider. So this one's a disposition of remains. And the important part on this is usually on the death of a second spouse or if you're unmarried. Because if it's your spouse, that's not a problem, right? They're going to be able to come in and they're going to talk to the funeral home, and the funeral home's going to have no problems releasing your remains to them. However, if you aren't married at the time of death that you pass away, there is nothing that's provided for a significant other that you're not married to. There is, and then there's this level of priority as to who gets to make decisions with regard to your body. And this goes from like who can the mortuary release you to setting up burial and funeral decisions. Who can pay for that? Like, because obviously, unless you pre-set it up, they always want to go with, well, who's going to pay for this? That's usually question number one. And so this allows you to pick somebody because your will not have been filed with court by this time. So your personal representative is not a whole lot of help at this point. But you can say, oh, I want trusted son number 2 to do this. Or I want niece number 3 to do this, or I want my best friend to do this, or I want, somebody from the church to do this, or whatever it is. And so it's a form that lets you make that decision as to who basically the mortuary can release your remains to, and who can make the decisions to follow whatever plan you've got set up, whether that be body donation, whether that be a specific funeral arrangement, whether that be cremation or burial. So it's a quick form. It's not nearly as uncomfortable as the advanced healthcare directive, but it's one that kind of fills that gap that exists, because if they can't find someone, then a funeral home can't release you for a while if they don't have for certain who you're supposed to go to. So you can delay it for a few weeks, which is not so great. So no, that's fun. So yeah, so that's kind of that form. Its usefulness is for a very short period of time, but it's one that I'm having more and more people be interested in doing, because the order of priority, and it follows like an intestacy priority. So it's going to say, first spouse, and if you don't have spouse, then you're going to go to kids. And if you've got multiple kids, maybe you're like, I don't want this one to make that decision because maybe it will be too hard for them, or maybe it will be, though they've always, they don't believe in what I believe in when it comes to that, whatever it may be. And you say, no, I want this other child to do this, or I don't want any of them to make those decisions. And so if the order of priority that by statute isn't what you're comfortable with, then it doesn't make sense to do that.
I have a question. If you've made pre-arrangements with the funeral home, does that make this form unnecessary, or?
It makes it a little bit easier. It depends on the mortuary. Because what happens is when someone passes away, then it has to go to the mortuary so that the medical examiner can make determinations as to cause of death and that kind of stuff that goes on the death certificate. And so if the mortuary understands that you have given the right to the funeral home to be picked up, essentially, then they're usually okay with it. If they're not, they're just going to wait the time frame for someone to come forward and say, hey, I get to make those decisions. So if you have it in place, then the funeral or the mortuary has no problem with who they can release the body to. And then that person would then follow whatever you've got in place.
Thank you.
Yep. All right, so that was a super fun one. We don't have to dwell on that one too long. Okay, so then I've got this. It talks about how to choose an attorney in fact or a medical representative. I have lots of clients who say, okay, I've got a bunch of people that could do this, or even worse, I've got no one that can do this. So I feel like I have no options. Like I just don't know who the right choice is. And the right choice for you may be entirely different than the right choice for your spouse, maybe entirely different than the right choice for your friend or anybody else. And so often it's spouse first, right? That's normal. But let's say you don't have spouse, or even if you do, you always want to make contingency plans. A lot of clients will say, okay, I'll have my children make the decision, right? Some go birth order, some go who's the most responsible. Some want people to serve together, together as co-representative, together as co-attorneys, in fact, and that's fine. Co's are great as long as they agree. The co's are not great if they disagree, because then, like my least favorite thing is to be like, hey, Judge Holland, we've got some issues, and now no one can serve, because that's what happens. Judge Holland won't split the baby. She'll be like, we're done. Baby goes to like some brand new person now. Because they don't want the divide that happens, the family fractures in those situations are deep. And usually both parties are equally prepared to do it, but it makes us impossible to choose who should do it. So as long as they get along, co's are fine. But there's never a requirement, and no one should ever feel like they need to choose children. There are good examples of why to not choose your children to be a personal representative. For example, a personal representative, attorney in fact, or a healthcare representative. If there is a lot of issues that are going on between your children, like they don't like each other, children are not a good option. The reason being is that what happens is one will have all the knowledge and the other ones will feel as though they are being left out, and it will exacerbate whatever their dislike or discomfort is with each other, because one will be in the know and the other ones won't be. So that is not a good option if they don't get along well. Now, if you have one kid, that's great, unless they're not responsible. And that's kind of the other part. If you have irresponsible children, I could think of my siblings, then you don't want them serving, because the money, like if they're not good with their own money, they're not going to be good with your money. And that's a really uncomfortable position. It also puts them at financial risk and risk of criminal litigation. So we don't put irresponsible children in charge of money. So maybe you're like, okay, kids are out, done. We don't have them. That made it probably easier. What about a friend, right? A lot of people say, well, I've got these really good friends, but they're older than me. Or I've got these good friends, but they live, in like Canada. All of those are okay. If you've got someone that you trust, it doesn't matter if they're older than you, because you don't know what's going to happen. You can't predict the future. I would say that doesn't mean it's the only person on your power of attorney. Make sure you have multiple people on your power of attorney. Because really what it comes down to is, do you trust them? And if that's who you trust and they're 10 years older than you, go for it. Location is not a problem. Kind of what we talked about before. There's companies in town, there's companies all over that can be your boots on the ground if that needed to happen. So friends can usually be good. Again, you want responsible friends, but we do get rid of the family fracture issues. Other people say, what about family, right? Judy had mentioned her siblings. Again, same concerns, age, location. I wouldn't be as concerned about those. Maybe health. If you know someone's, like you have an older sibling and they're already in pretty not so great health, maybe that's an idea to say, not a good idea. The other part to think about is, again, we're back to family relations. If you name somebody who others, like who your children don't like, or who other members don't like, and they have a hard time communicating, or they don't communicate honestly, then they're not a good choice. The best gift that anybody can ever give their family is having people in charge who openly share information, who are honest in their communications, and who are willing to document what they're saying. Because that is how we avoid litigation on the backside, because it is very common that we litigate powers of attorney after someone passes away. Other big things with that, if you make gifts, you make them always in writing. You don't say, oh, child number 2, you can have my china set, put it in writing. I don't care, put it on a sticky note, put it on something, put it in writing. Because it'll be this contention that exists where if you're like, oh, but mom said I could have, and then the other one's like, but mom didn't put that in writing. Always, always, always put everything in writing. If you're ever giving anything away, postmortem. If you're giving away during your lifetime, make sure they actually take it out of your house. Then it's okay. So it's stuff like that that is kind of important things to think about. Last one is, often I have people say, okay, I don't want my kids to do this. I don't want them to have that stress. I don't have a close family. I don't like my family. I don't want my friends to be burdened with this. All my friends are 50 years older than me. So who do I choose? I have no one. And that's when we talk about professional fiduciaries. And often this leads to the conversation of cost and who are these people? Like who, somebody coming, some third party coming into all of my stuff. Like, do I trust this? And there's a couple of things about professional fiduciaries. I can't necessarily talk to their cost because that's their own decisions, but it's a lot less than litigation. So there's 3 in town that we've got. We have Oregon Advocates that is owned and ran by Gazelle Fuller and Jackie Fosbach. They are both licensed, bonded, insured. They're on the Oregon Guardianship and Conservatorship Council. They get appointed in cases all the time. They are a great resource. And all 3 of these do similar things, right? They act as professional fiduciaries. They get appointed by court in conservatorships and guardianships. They're trustees. They do care contracts. We have, like, some of them, I know that Jackie and Gazelle pretty well. They do care contracts. And so they are the eyes and ears for family if something happens. Over at Cornerstone, it's Todd Thomas and Anya Danielson. They've been around a long time. Todd is one of the nicest men you'll ever meet. And so they, same thing. They're licensed, bonded, insured. I know Todd has been on the member, one of the executive members of the Oregon Guardianship and Conservatorship Council. So they all know what they're doing, and they get appointed in cases all over the state. And then the last one's Avanti with Karen Fabiano. And same thing, very good at when it comes to the financial side of it. She's licensed, bonded, insured, and manages, care contracts for a variety of clients. And all 3 of them, it's not just, when someone's losing capacity. I mean, they represent, minors in situations. They represent people with learning disabilities. The other great thing about these ones is they're great resources for things like Social Security disability eligibility and like VA benefits. In fact, Jackie Fosbach is excellent VA benefits because the struggle she had to go through with her husband on his VA benefits. So she is kind of a wealth of knowledge on that kind of stuff when it comes to like aid and attendance or any of those, VA benefits that are entitled to spouses or to the veteran themselves. Okay, so kind of, wrapping that part up. If you are in a situation where you need somebody to serve because you don't have anybody else in these categories, or sometimes we'll even have them serve as co's, like maybe it'll be son and a professional fiduciary, or daughter and a professional fiduciary. The benefit to that is that you get somebody who knows what they're doing to watch over what the person who's not doing this all the time, what they're doing. So they definitely serve as codes on things as well. Yeah, so I think that kind of covers the ideas of like who to appoint. Do you guys have any questions?
I have a question about your, what you said at the beginning about the yearly update by the committee for the Advanced Healthcare Directive. Are these guidelines updated every year, and should people more or less review their document every year and update it?
That's a good question. So it's the committee meets every 2 years, and sometimes they update it and sometimes they don't. I'm actually hoping to have a conversation with one of the committee members about the laws regarding powers of attorney and advanced healthcare directives, because unlike trust law and laws that happen with wills, that's been like, those are laws that are fairly universal in most places. And there's been so much about those that it's pretty straightforward. Now, when it comes to powers of attorney, those laws are not super friendly. They're not very clear, and I would love to get something better written into our statute that provides more guidance on someone who acts in a fiduciary capacity, what their obligations are, and who they have to report those to, which is why I have it in my document, but I'd rather have it be more of a universal thing. So to kind of circle back around to your question, it is always good to relook at your documents anytime you have a substantial change that's occurred, whether that be the person you know who you've named has passed away, or multiple people that you named have passed away. It's always good to go and look and say, am I still comfortable with what I've got? If you're not, it's really easy to redo those documents. If you're like, no, everything still looks good, then don't worry about it. You don't have to, just because let's say choice number 1 passes away, you do not need to revise your documents. It's easy for us to show that number 1 passed away, so number 2 steps up. That's not a problem. But it's when from 19 to 2021, that was a substantial change. And so, but people that really care, I feel like people that cared about having extra information, they did the addendum, just like Mariana did. And so I think that if you're good with it, if you're like, nope, this still meets exactly what I want it to say, what's important to me, leave it alone. No reason to have extra cost and time if you're good with what you've got. All right. I was impressed that I actually spoke that whole time. That was pretty good.
Good job. Are there other questions? If something comes up, sort of like when you go to the doctor, when you get to the parking lot or halfway down the block, you think of your questions.
Oh, yeah.
If that happens, you have Megan's direct email in the invitation that I sent out, or you can contact me. Everybody knows how to do that, and I'll get the questions to Megan.
Absolutely. I'm happy to answer any questions. And I think Judy Goldstein, do you have a question?
Well, I thought we were going to talk a little bit about wills.
I can. I've got more on there. I just don't want to take more time.
I mean, I don't know. I know the time about the time.
I certainly can. Yes, I talk about them all the time. So
Well,
yeah, let's talk a little bit about wills. I'm not going to go
Sure.
extensive into it, but and I didn't prepare a slide for this part of it, but my number 1 question that I get in my office is, what's the difference between a will and a trust, and why do I need what? Yeah. So do you want me to talk about that?
Sure.
Okay. So there's 3 reasons that people get trusts, mainly. 1, they have children from prior relationships and they are concerned about accidental disinheritance. Number 2, they value their privacy. And so a will, when you pass away, a will becomes public. It's a public document. It gets filed with court. Anybody can go into the courthouse and pull up a copy of your will. And then number 3, the big reason is for tax benefits. And this is where the vast majority of my conversation ends up hinging upon. So in Oregon, there is $1 million tax exemption for each person when they pass away. We don't have gift tax, so you can give away as much as you want during your lifetime. And it does not account against your estate tax credit that you're going to get. So what happens is if you are married and you have got obviously 2 people, right? Then you've got $2 million that you can pass tax-free. But the big problem is Oregon did not adopt something called portability. And what portability means is let's say spouse number 1 dies. Okay, so now you only got 1 left. That $1 million exemption dies with them. So if it says everything to my spouse, which is normal, there's no tax when that person dies. But now the surviving spouse only gets $1 million to pass tax-free. Now, federally, even though it's much larger numbers, they adopted the idea of portability. This is the part that Oregon should have adopted, but that's fine. So what they say is, okay, you've got 2 spouses and the first spouse passes away. We're going to give the $2 million or the $1 million to the surviving spouse. So now the surviving spouse has $2 million to pass tax-free in Oregon numbers, not real numbers, not federal numbers. But because Oregon didn't adopt that portability and said, nope, when the first spouse passes away, so does their exemption unless you use it, it's gone. And you never use it if it's all the spouse. So when spouse number 2 passes away, if they have more than $1 million in gross value of their estate, not net, they don't care about the taxes you owe, the medical bills you have, the credit card bills, nothing, not your mortgage, nothing. They do not care. And it's $1 million anywhere. It's a global value. So if you owned property in Colorado or in Texas or in France, they are going to include this in the value of your estate. So it's kind of a bummer. So what happens is with a trust, what you can do is you have one trust document, right? So one document, and you say, okay, during both of our lifetimes, we're gonna have everything go as normal, right? No big changes for you guys during both your lifetimes. On the death of the first spouse, we are gonna say, oh, we've got more than $1 million in assets, gross value of assets, and we're gonna take it and we're gonna have our one trust in the same trust document, divide into 2 trusts. And we're going to put up to $1 million in what's called the disclaimer trust. It's called the disclaimer because what I do is it's kind of like real life tax planning. So there's no mandated written in like, oh, on the death of the first spouse, you have to divide it this way. It gives you the option to sit down with the CPA and say, hey, this is my financial situation. These are my assets. I want to disclaim some of these. I want to say, I'm not taking them, so I'm going to push them into this trust. So that if you don't need it, you don't have to do it. If you do need it, it's there. So up to $1 million goes into the disclaimer trust. And then the surviving spouse is the beneficiary of this trust. It's also an irrevocable trust. You cannot change this trust. You cannot change the beneficiaries. But because it's irrevocable, the Oregon Department of Revenue says, this trust was never owned by a surviving spouse. And if it was never owned by a surviving spouse, we're not including it in their estate when the surviving spouse passes away. So the only value they include is the money that's in the surviving spouse's trust, that second trust. So example, let's say when the surviving spouse or the first spouse passes away, you have $1.5 million in gross value, which honestly, not very hard to get to nowadays, with especially the market the way it is. And you say, okay, I'm going to disclaim $1 million into my disclaimer trust. And the other 500,000 is going to go in my surviving spouse trust. Time goes on, surviving spouse trust, stays at 500,000 or does whatever it's going to do, but it doesn't go above $1 million. And the $1 million stays in the disclaimer trust. Well, kind of, I draw it where it like circles back around. On the death of the surviving spouse, Oregon Department of Revenue says, I don't care about the $1 million in the disclaimer trust. I only care about the 500,000 that you've got in your surviving spouse trust. Because it's not more than $1 million, you pay no estate tax. And then we distribute it out according to whatever beneficiaries you've got on both trusts, right? And normally they marry each other. Normally it's the same beneficiaries. And so that's how you're able to kind of do a version of portability to force the preserving of that $1 million exemption. Now, same example, let's say no trust, just a will. At the death of the first spouse, you have $1.5 million combined. Okay, all the spouse. Now spouse gets $1.5 million in their bank account or, you know, combined assets. And time goes by, surviving spouse passes away. Now Oregon's going to say, whoa, okay, all of her assets at the time of her death is worth $1.5 million, which means your family or your estate is now going to pay $500,000 of estate tax, which is about 15% of that is estate tax. And because we didn't, even though it's the same dollar amount, because it wasn't into the two trusts that you then, the one trust and then splitting into two, you have to pay tax on it versus the other way we didn't have to pay tax. So it allows us to pass up to $2 million without paying any estate tax versus with the use of the trust versus the will.
So if you're single, this is all irrelevant.
If you're single, what we do is there can be some very specific language in your estate documents, and you can use a will for this, that provides for charitable giving up to the value, basically to reduce your estate to $1 million. If we reduce your estate to $1 million, there's no estate tax. But that depends on if it's like, what's more important, the giving of it or the estate tax. So normally with someone who's single, it's other reasons they have it as a trust. Sometimes, and very common if you have any from California, they say, oh my gosh, probate's the worst thing like ever. I don't, scary, run quickly, other direction. Must have a trust. That's a very common reaction from someone from California. Probate is not that bad in Oregon. We run it the same way we run a trust. We still have to give notice to creditors. We still have to go through the process. The big difference is with a probate, we have the court being involved and overseeing kind of everything. In a trust, you don't. And there's no obligation to even hire an attorney. It's usually not a good idea, but there is no obligation. And those are the ones that get litigated. And so, I mean, but there's no oversight, right? So that's the big difference. Oversight, no oversight. About the same amount of time to process both. So I guess this one's a teeny bit, probate's a teeny bit more because you have filing fees. But overall, not that bad. So if I have somebody from California that's like insistent upon I need a trust because I'm afraid of probate, that's fine, no problem. The one plus is you do have access to funds more quickly with a trust because the trustee will be able to step right in immediately. So you do have access to funds without waiting for court to approve.
And probate
So
can
that's
take a while.
Mm-hmm. And it's a plus that during your lifetime, because one of the issues that are frustrating is if we've got a trust, then the trustee can immediately step in and say, okay, the successor trustee, which again, you choose who that is, they can step up and say, okay, we're going to have access to the trust and we're going to do, whatever needs to happen to help or to pay for the original trustor's living expenses or medical or whatever, right? They're going to follow the terms of the trust the way you've got it. With a power of attorney, it's usually things are not well organized, because with a trust, right, one of our very last jobs of the trust is we've created this trust, now we have to fund it, right? Because the trust has to have what's called corpus, has to have a body to it. And so what we do is we say, okay, we're going to move the house in, we're going to move the bank accounts in, we're going to move the investment that are non-retirement investment accounts in. And so we're going to have everything kind of under this one bubble, right? It's all in one spot. When you don't have that and you have just a power of attorney and a will, often your assets are kind of all over the place. And sometimes getting that information, specifically in an age of everybody's going to online statements, bane of my existence. I'm like, no online statements, because it's very difficult when I'm like, no, I need that to know what your assets are. And if a power of attorney isn't, daily in your mail, it's very difficult for us to know, like, okay, there's this account over here and there's this account over here, and we've got all these different parts moving. So the trust is a little bit nicer because we can usually encapsulate that a little bit more. So that's a plus. Another plus to having a trust, even if you're in a single position. Yes, Judy.
just quickly, you mentioned irrevocable trust, and I know there's such a thing as a revocable. I don't quite, it sounds like you wouldn't want it irrevocable, you would want an irrevocable, but I think my family has done revocable.
Yes, so revocable is common. So that's how most
Revocable is what?
revocable, the revocable ones are very, very common. People
Oh.
call them living wills. They call them revocable living trust. They call them a variety of names. So most trusts start being in the process, they are revocable by the people that made them. Now, when both people lose capacity, that's when a trust becomes irrevocable. When both people pass away, the people that made it, they become irrevocable. When we talked about doing the split, right? So death of the first spouse, and we're going to say, okay, the disclaimer trust is irrevocable. And the reason why that one's irrevocable is to keep it out of what the Oregon Department of Revenue determines is your control over the asset. Because if you can't change it, if you can't say, okay, I'm going to change the beneficiaries and do all this other stuff with it, then it was never really yours to begin with, right? You're just the trustee. A trustee owns none of the assets. They're just in charge of them. But you would be not only, you'd be the trustee and the primary beneficiary. So that means that even though you're the trustee and you don't own it, you can still draw funds from it to support your lifestyle. So that's when they become irrevocable. There are some trusts that it makes sense for them to be irrevocable, but those are very, very specific. A lot of the times, the whole reason that we're doing them is to avoid estate tax. Like some people, when you get divorced, you have a life insurance obligation for either child or spousal support, and you already are going to have an estate tax because of the value of your assets. We don't want to like exacerbate that by having you get this big life insurance policy. And because the life insurance policy that you own on yourself is included in your estate. If your husband buys a life insurance policy on you, or if your kids buy a life insurance policy on you, that is not included in your estate. But if you buy it on you, it is included in your estate. So in those situations, we don't want to do that. And we put it into a very specific irrevocable life insurance trust. But yeah, the vast majority of trusts that are used for general estate planning are revocable trusts that you can change as much as you want, as long as you're the original trustor. Oh, you're very welcome. All right. That was kind of a short and sweet of, can be much longer conversations.
Megan, thank you so much.
Oh, you're very welcome.
I will
This
put
was
this.
very helpful.
Yeah.
Thank you.
Absolutely. Thanks very much. And again, if anyone has questions afterwards, get them to Megan or to me. And I'll
How can-
also make that little checklist you had, anything you'd like, Megan, to make available to folks, forward
Sure.
to me, and I'll send it out.
Yep.
All right. Well, thank you. We
Oh, you're very
appreciate
welcome.
everyone coming and joining us, especially you, Megan, with all of that great information. Go forward and stay warm and dry.
Good luck. It's been pretty rainy.
Be
Thank
well and
you all.
prosper.
Thank you so much. Perfect.
All right.
All right. I will see you guys
Bye.
later. Have a good rest of your weekend.
You
Thank
too.
You too.
Bye-bye.
Bye-bye.